Welcome, everyone, to this, our 12th session of the book club, Reasoned Argument, the Counter to Cancel Culture. Well, we've gone through the great rhetoricians, and now, in many ways, we're on the downhill. That is, I'm going to contrast in this session and the next how far we have departed from that which built such a great country. So let's begin and start again with three think points. Let me read them. First, losing our Republican Constitution. Here I'm going to go to Professor Barnett's book and do much of chapter 5. Second, Harvard, from Justice and Professor Story in natural law to Professor and then Justice Holmes and Positivism, Progressivism, social Darwinism, and Scientism. 3, Princeton President, later US President Woodrow Wilson, in ditto, that is the same thing, Positivism, Progressivism, social Darwinism, and Scientism. So, our first session, again, losing our Republican Constitution. Let's look at chapter 5. One has to wonder whether if Lincoln had not been assassinated, that there would have been a very different result. In any event, let's turn to just some of the language from Lincoln's second inaugural. With malice towards none, with charity for all, with firmness in the right, as God gives us to see the right, let us strive on to finish the work we are in, to bind up the nation's wounds, to care for him who shall have been born the battle, and for his widow and his orphan, to do all which may achieve and cherish a just and a lasting peace among ourselves and with all nations. Right before Lee officially surrendered, Lincoln had proposed a very generous Reconstruction plan for the South. It had its opponents in Congress who wanted to be more aggressive. But with Lincoln's assassination, he was succeeded by his vice president, of course, but Johnson was a war Democrat. So not being a Republican, he didn't have real friends in Congress. And as Professor Barnett points out, especially on page 104 and thereabouts, there's conflict here, and Johnson is certainly sympathetic to the South. But Johnson is not Lincoln. And Lincoln had his own difficulties with Congress. But Lincoln was the great man, the hero that might have gotten through the whole situation in a way that dampened the passions. And there were violent passions going on. I mean, it was both in the South and some in the North. That is, in the South, there was great bitterness towards the North for having lost and to the North and not being able to separate. But in the North, there was a mixture of both good intentions and towards the Reconstruction amendments. But also, among some at least, there was a spirit of revenge. And that great difficulty is one that calls for somebody to heal the wounds. Unfortunately, no such great man was present. And it is a situation that quickly devolves into, as Professor Barnett describes, losing much of what is gained by these Reconstruction amendments. Professor Barnett discusses the Slaughterhouse Cases from New Orleans in his pages 115 to 19. When I used to teach this at LSU, I would always bring out an article from the time in the New Orleans paper describing the monopoly that was given was just another payoff, as has often been the case in the past in Louisiana. But it raises a very important question about interpretation, both of the 13th and the 14th Amendment. But the one that really sticks is that part in the 14th Amendment dealing with the Privileges and Immunities Clause. And part of it has to do with this, with uncertainty or ambiguity. That is, on the one hand, there have been over time different understandings of the Privileges and Immunities Clause, both in Article 4 and the Privileges or Immunities Clause in the 14th Amendment. Often, the amount of time spent in a constitutional law class on this is very brief, and there is usually the reference to an opinion by Justice Bushrod Washington in the Corfield versus Correll case, in which he gives a definition of privileges and immunities that's not terribly clarifying. This is quoting Justice Washington. What these fundamental principles are, it would perhaps be more tedious than difficult to enumerate. They may, however, be all comprehended under the following general heads: protection by the government, the enjoyment of life and liberty, with the right to acquire and possess property of every kind, and to pursue and obtain happiness and safety, subject nevertheless to such restraints as the government may justly prescribe for the general good of the whole. Interest in the Privileges or Immunities Clause of the 14th Amendment increased with the dissent by Justice Thomas in the 1999 case of Saines versus Roe. It was a so-called right to travel case. Justice Thomas dissented. He didn't see it that way, and he didn't agree with the Slaughterhouse case. And he thought that it was important to focus on this. And since then, there's been more attention paid to it. And what's ironic about the Slaughterhouse case is that, being from New Orleans, it had a background of the French civil law. And French civil law is derived from Roman law. And if you look at the 14th Amendment, it is clearly, although very rarely mentioned, that it is in the form of Roman law. And there's an important reason to look at this. The Privileges and Immunities Clause is for citizens only. The Equal Protection Clause and the Due Process Clause are for all persons. Well, why? Why don't we clarify the difference between rights of citizens and rights of everybody else? Years ago, when I was still in law school and attended a conservative conference, a then famous constitutional law professor, who, as I would say, of the Holmesian school, noted that the reason why the court did not go down the privileges or immunities road was because of its fear of opening up, quote, natural law. We're going to see in a little bit that that pathway was closed or attempted to be closed by Justice Holmes from the time he was a professor, Holmes. But the point is that in Roman law, they had to develop a law that not only covered citizens, but gave citizens special rights that were not applicable to everyone else. But everyone was entitled to due process and equal protection of the laws. That's the 14th Amendment. So the distinction between laws protecting everyone and laws protecting citizens should have been important. Unfortunately, because of the failure to go down the privileges or immunities pathway, what we have is the application of rights that really are citizen rights to people who are aliens. That is, there is a difference between due process as process and substantive law and equal protection. Everyone is entitled to due process and equal protection, but they're not necessarily entitled to the rights of citizens unless they're citizens. And you can work that through in the constitutional law, especially since 9/11. Unfortunately, almost nobody does that. In any event, I would like to recommend that you look at a series available on the Federalist Society website by Professor Richard Epstein on Roman law, a basic introduction to it. Until Justice Holmes suggested getting rid of Roman law, which happened, it was expected that law students and lawyers knew something about Roman law. Indeed, the law of nations, with which the founding had to be very attentive to, was based on and drawn from Roman law jurists. So not having an understanding of Roman law is really deficient. I learned this years ago sitting through a master of Roman law from Cambridge University. And in the middle of it, I just woke up and said, gee, this is where we got the whole notion of federal jurisdiction and much of what we learn in federal courts. So it's not very available anymore, Roman law, but at least you can look at Richard's programs on the Federalist Society website. So next we're going to turn to Story and Holmes. That is, let me read again the second part of this session. Number 2, Harvard, from Justice Professor Story and Natural Law to Professor and later Justice Holmes and Positivism, Progressivism, Social Darwinism, and Scientism. On pages 125 to 130, Professor Barnett discusses Professor Thayer and Professor Holmes at Harvard, as well as Holmes on the bench. But before getting specifically into that, it's important to understand the role generally after the Civil War of universities, notably Harvard, but others as well. And so that background, I think, is critical to understanding, in particular also, the law school, what happens at Harvard Law School. So we're going to begin with the new president then in 1869 of Harvard, Charles W. Eliot, who was president for 40 years, which gave him plenty of opportunity that he used well to build a very successful and prestigious university. Even though Harvard had been around since 1636, it really takes off with this presidency. So let's look at some things about Eliot. It really is difficult to overstate the influence and the impact of Harvard on the intellectual life of the country. I know that people are generally aware of this and that Harvard is prestigious, et cetera, et cetera. But when you go back and you look at what happens beginning in 1869, it's not just the building of the institution and the faculty, it's what the plan of President Eliot was. Listen to what he says at the beginning of an article that he published in the Atlantic magazine before he was president. The title of the article is The New Education. Quote, a system of education which attracts no great number of boys, which unites its discipline in no strong bonds of common associations and good fellowship, and which, after years of trial, is not highly organized, has no strong hold upon the community in which it exists. In what he continued to describe as the suggested changes for a university, that a few months later resulted in his being appointed president. And that was a signal, more than a signal, a direction to change Harvard in a way that has been characteristic ever since. And what was that direction? Well, let's read from another Atlantic article, much closer to the current day, from an admirer describing what the goal of Eliot was. This is by Russell and Alley, who at least at the time was director of education at the Emerson Collective, which is, or was at least, the majority owner of the Atlantic. And she writes about Eliot, quote, Addressing a nation riven by civil war, Charles Eliot offered a solution for its dangerous disunity: education. Quote, "The American people are fighting the wilderness, physical and moral," he said, on the one hand, and on the other are struggling to work out the awful problem of self-government, he wrote. For this fight, they must be trained and armed, in a word, educated. That was Eliot's solution. In other words, he's proposing that universities in particular, but also K-12 schools, they are the bond of unity nationwide. And of course, Harvard is going to be the leader in all this. So what is being put out is an attempt to get more of a common education nationwide. And that's largely successful over the years. But then the question is, what kind of education? Well, I want to read this from Samuel Eliot Morison, a famous historian at Harvard and kin to Charles Eliot. But this is after Eliot has not only left the presidency, he's died. And Morison is writing the 300-year history of Harvard. And he has a nice thing to say about his kin, but he also has something that's quite devastating. Let me read. He says that President Eliot was a representative of, quote, the best of his age, that forward-looking half century before the World War, meaning World War I, when democracy seemed capable of putting all crooked ways straight, the age of reason and of action, of accomplishment and of hope. Okay, now pull me in. But then he goes on to say, it was due to Eliot's insistent pressure that the Harvard faculty abolished the Greek requirement for entrance in 1887 after dropping the required Greek and Latin course for the freshman year. His and Harvard's reputation, the pressure of teachers trained in the new learning, and of parents wanting, quote, practical instruction for their sons, soon had the classics on the run in schools as well as colleges, and no equivalent to the classics for mental training, cultural background, or solid satisfaction in afterlife has yet been discovered. It is a hard saying, but Mr. Eliot, more than any other man, is responsible for the greatest educational crime of the century against American youth, depriving him of his classical heritage, depriving students of their cultural background, included depriving them of the background necessary to understand the Constitution. And why? Well, we're going to see that one of his top 3 achievements, he said, was his appointment of Dean Langdell at Harvard. And as dean of the law school, Langdell is famous for having instituted the case method, which virtually every law school in the country uses primarily. And that method has many benefits to it. But at the same time, there were certain elements scrapped. So prior to this time, students read from books on what the law was. And indeed, the books that many of them were reading were the books written by Justice Story, because Justice Story was teaching at Harvard at the same time he was riding circuit as a Supreme Court justice had to do back in those days. And the chair, the Dane chair, which Story received directly from Dane, was for the purpose of Story writing a number of books, treatises on the law of certain areas that were not the laws created by any particular sovereign. And that's going to come up as we get into Story versus Holmes. In any event, Story had initiated the Socratic method at Harvard, which Langdell kept. So we have a combination of Socratic method and case method, and it has many benefits to it. But it also allowed something else. It allowed the manipulation of cases to change the law. So let's look at this additional quote from Justice Holmes. This is probably the most famous quote from Justice Holmes. Actually, it's from The Common Law, his book written in 1881. Quote, "The life of the law has not been logic, it has been experience. The law embodies the story of a nation's development through many centuries, and it cannot be dealt with as if it contained only the axioms and corollaries of a book of mathematics." So what's going on at Harvard at this point? Well, Eliot, Langdell, Holmes, they're all progressives. And they're all buying into various aspects of the isms that are floating around at the time. So Langdell really is engaged in a kind of scientism as he tries to make the analogy to biology. Okay, so in the Oxford English Dictionary, the quick reference part, which is available to all, of scientism, it says, "The belief that scientific method can be applied to all problems with the consequent application of inappropriate scientific methods in unsuitable circumstances." The word scientism is controversial in its definition. There are different definitions given. But one that some people give is to the effect that if people who believe that the only kind of knowledge that you can really get is from science, that you can't get it from other sources such as religion or reasoning philosophically, that can be scientistic because it reduces our scope of knowledge and renders everything subject to, quote, the scientific method, even though they may not be accurately approaching or using the scientific method. You hear it too often today where somebody says, "I follow the science." Well, what does that mean? Does it mean there's no human judgment involved? No. Science is often latched onto as an excuse for the failure to demonstrate what your actual premises are, what you're working from. In any event, the word science has been badly used because in the 19th century, what happens is it gets compressed. What do I mean by that? Science before the middle of the 19th century meant an organized body of knowledge. The reason why the common law at Oxford was not considered a fit subject for a university was because before Blackstone, quote, "It was not a science." It wasn't an organized body of knowledge. It depended largely on the forms of action. It was taught in the Inns of Court. Why? Because practice was taught. And you looked at the forms. It wasn't about substantive law. Now, in the 19th century, that begins to change, and we move away somewhat, increasingly until the 20th century, from, quote, the forms of action. And it's more about substantive law. But under Langdell, what's happening is that there is a manipulation of the substantive law. Holmes wrote his work on the common law, and his biographer admitted that he wasn't really accurately stating what it was, he was manipulating it. Now, the only basis for the common law coming into the university at Oxford was with Blackstone. And what did he write? He organized the law, largely using Roman law categories, in a way that made it comprehensible to the ordinary person who studied it, who didn't have to go into the practice of law. He published this in 1765 to 9. As a result, the colonists read it. They were very well versed in the English common law, thanks to Blackstone, who was a Tory and no supporter of breakaway colonies in the New World. But that was a science. That is an understanding of law. And that's why it was widespread. Well, what we get at Harvard under Langdell is a new kind of approach, case method, but one which is getting rid of the idea that law itself is a science in the old understanding of that. Now it's going to be a science that's very different. For Langdell, he tries to analogize to biology, and that the law books in the library, these are the specimens like you'd find in a biological lab. But this is really scientism. This isn't science. It's really a change in rhetoric. What happens? That rhetoric is going to change, and it's going to be grounded now, not in eternal principles, not in the science of law as it was understood, but a new premise. And what is that premise? Fundamentally, that all knowledge really is real knowledge, has to be scientific.
I get it. I understand your frustration. We're all searching for ultimate #truth, and complex, challenging ideas don't always fit nice and neatly in our brains. But what is truth? Are there different levels of truth? Are some truths truthier than others? Well, I don't know, but I do know this. Science is the absolute best tool we have for understanding how the universe works, and theory is not a four-letter word.
Oliver Wendell Holmes, then a professor at Harvard, is like Langdell in the sense that they're both progressives, but his attitude towards law is slightly different. He is the apostle of positivism. First, I want to read a statement by Holmes regarding his bad man theory of the law. Quote, "If you want to know the law and nothing else, you must look at it as a bad man who cares only for the material consequences which such knowledge enables him to predict, not as a good one, who finds his reasons for conduct, whether inside the law or outside of it, in the vaguer sanctions of conscience." Holmes's emphasis is on the force of the state to enforce law. Some of this may come from the cynicism he seems to have developed from having served in the Civil War and understanding the terrible, terrible consequences of the rule of law breaking down. Nevertheless, I would submit that Holmes's change in the understanding of law has created a different and ultimately, I think, equally dangerous approach to law. Let's continue with what he has to say about natural law, because it has a practical consequence in terms of how constitutional jurisprudence proceeds from the middle of the 1930s on. First, from Southern Pacific Company versus Jensen in a dissent, quote, "The common law is not a brooding omnipresence in the sky, but the articulate voice of some sovereign or quasi-sovereign that can be identified, although some decisions with which I have disagreed seem to me to have forgotten the fact." In his article on natural law and some of his other talks, Holmes would take aim at natural law, and that's can be reflected in the following statement from his article. "The jurists who believe in natural law seem to me to be in that naive state of mind that accepts what has been familiar and accepted by all men everywhere. No doubt it is true that, so far as we can see ahead, some arrangements and the rudiments of familiar institutions seem to be necessary elements in any society that may spring from our own and that would seem to us to be civilized. Some form of permanent association between the sexes some residue of property individually owned, some mode of binding oneself to specified future conduct. At the bottom of all, some protection for the person. But without speculating whether a group is imaginable in which all but the last of these might disappear, and the last be subject to qualifications that most of us would abhor, the question remains as to the ought of natural law. Notice that many of the things that he is talking about, he says may wither away, including the right of property, and that even personal liberty may be compressed in the future. Why? Under positivism, there is no standard. Positivism can't really accept the Declaration of Independence. And it's not surprising when justices of the current Supreme Court have said in the past about the future in terms of what the place of the United States may be in a world order. If you're a positivist and at the same time a social Darwinian, really an evolutionist in law, instead of calling it living constitution, let's call it what it really is, an evolving constitution. That is what many in the law profession and many on the bench believe. And therefore, we don't know what is true. We'll just have to see as things evolve. This is very much a notion of living simply by the circumstances and the evolvement of history, not by any fundamental principles about anybody's rights. Given a Holmesian understanding, and many lawyers and judges idolized Holmes as the perfect judge, the reality is also that many conservatives did, because they think he was just the model of judicial restraint. Professor Barnett, I think, does a good job of pointing out that judges aren't supposed to be restrained where they're not supposed to be restrained. There are points at which they should be restrained. The question is the text of the Constitution. Who has the power? That is, does the court have the power to rule on such and such? It involves many issues, including standing and the other case or controversy issues. But if it is an issue before the court that is properly there and it falls within their scope, they're not supposed to duck the issue by simply saying we should be deferential to the Congress. There's nothing in the Constitution about that. Indeed, the court was designed to be there to protect the Constitution against Congress. Remember what Madison said in Federalist 47 and 48. The legislative branch is the most dangerous one. It's the one you've got to keep your eye on. That's why we have a court. But after the middle of the 1930s, that all changed. Congress took its eye off. The court took its eye off of anything that Congress passed. And Congress got used to the fact that anything they threw up there, the court would approve. They didn't worry about it until the 1990s, when in the Morrison case and the Lopez case, the court struck down a couple of statutes, federal criminal statutes. And some members of Congress were outraged. How dare you do this? That's the court's job. Professor Barnett discusses Justice Story's opinion in the case of Prigg versus Pennsylvania, and he's quite critical of it, and certainly criticism is well-deserved in many respects. In particular, though, he says that this is an example of Justice Story being deferential to Congress and also an example of judicial restraint. He is, in fact, deferential to the first Congress, which passed the fugitive slave law in 1793. Much deference is generally given to actions done by the first Congress because it included many who were in the Constitutional Convention, and there was an assumption that they knew what the meaning of certain provisions was if an issue of interpretation came up. On the other hand, I think that there's a good argument, and it was made by Frederick Douglass, that the actual words of the provision from which this fugitive slave statute supposedly drew its authority don't support that authority. But we heard that already from Frederick Douglass. What you wouldn't know from reading Professor Barnett's book is that not only was Story against slavery, but he actually gave, as a justice, anti-slavery speeches. Now, can you imagine any justice today giving a speech on an issue that might come before the court in which he or she had a strong opinion? That justice would have to recuse himself or herself from that matter. Now, standards on recusal have changed over time. The point is that Story was not someone to go light on slavery, and he was not someone to be terribly deferential to Congress. In fact, he was, as indicated, the ally of Marshall. And in that capacity, he tried on several occasions in matters involving admiralty and the slave trade to have Marshall come out and say, or agree with him, that slavery violated the laws of nations and the law of nature. But Marshall took the position, although he is against slavery, that it wasn't the case, that the law of nations as custom supported slavery, and so he couldn't rule that way. In any event, the issue in between Holmes and Story is all about natural law. And Story had written an article on natural law, and an anonymous one, which was common at that time. But it was clear that he understood and supported and lived natural law, although it didn't necessarily come in as a term into his decisions. But there is one decision in which it did come in, and that was Swift versus Tyson. And Swift versus Tyson is a case that Holmes said was unconstitutional. Apparently the only decision of the Supreme Court ever said by a justice to be unconstitutional. In any event, Swift versus Tyson concerned an area in which Story had written, and he was the one that people followed in his understanding of bills and notes. And in this case, to simplify it, the court, under his opinion, refused to follow decisions of a New York court. And he said that decisions of courts are not, quote, law. They are only opinions about what the law is. He made a distinction and said, had the New York legislature adopted this position, it would be a law, and it was provided for in the particular federal act that he was interpreting, then the court would have to defer to that. But in a matter not governed by law in the statutory sense, that the court dealing with a matter that crossed state lines would apply the understanding of merchant law. At the time, merchant law was an independent, or had been, an independent source of law coming from no sovereign. It had been incorporated into the law of England, and the Supreme Court adopted the same kind of approach to what's called the law merchant, the law created by merchants themselves, not by sovereigns. In any event, Holmes rejected that whole notion, and more importantly, he rejected the notion that what judges say is not law. And that idea originates in this country, at least, precisely from Holmes, saying it is what judges say is law, not just an opinion on law. Now, lawyers have always treated what an authoritative statement of law as binding until it's changed by a court. but that's different from saying it is necessarily the law. Holmes's victory over Story is announced in the famous case of Erie Railroad versus Tompkins. Holmes is gone from the court at this point, but his ally Brandeis writes the opinion, and let me read the critical passage. Thus, the doctrine of Swift versus Tyson is, as Mr. Justice Holmes said, quote, an unconstitutional assumption of powers by the court of the United States, which no lapse of time or respectable array of opinion should make us hesitate to correct. In disapproving that doctrine, we do not hold unconstitutional Section 34 of the Federal Judiciary Act of 1789 or any other act of Congress. We merely declare that in applying the doctrine, this court and the lower courts have invaded the rights which, in our opinion, are reserved by the Constitution to the several states. Now, there's reasons in which a tort case like Erie Railroad are distinguishable, but weren't being distinguished from a law merchant case, which was Swift versus Tyson. But the key part for both Brandeis and Holmes is the philosophy behind it. It is the enshrinement of positivism, and that's not good news for liberty and rights, because as Holmes has already shown, these things are matters of change. Conservatives, unfortunately, generally praise Erie because they read this line about being left to the states. Well, I mean, that's a fig leaf for this case. Why? In the same year, in the Caroline Products famous footnote, the court indicates that it's going to take more aim at individual rights, not property rights. And where those rights being identified? They're in the states. So what in effect the court does is it gets rid of a notion of common law being common to the states. And instead, now we have constitutional law that spreads. Well, what does that mean? That means the court is in control of this new constitutionalized common law, whereas common law could be changed in the states. So there are different ways that courts can maneuver, and this is a fascinating maneuver that is part of the progressive movement as understood through the positivist lens of Justice Holmes. Lincoln had to address the impact, the effect of the Dred Scott case on a number of occasions, including the Lincoln-Douglas debates and in his first inaugural. I'll read shortly the parts of the first inaugural, but essentially what he made a distinction, if you read several of these, is between the judgment in a particular case and the weight of precedent, as well as the role of Congress. We all know that a judgment is binding when it's final on the parties, and he didn't dispute that. What he did dispute was the validity or the weight to be given to precedents. In large part, he made the distinction that there were some precedents that were readily accepted by people, and therefore they became solid as a matter of custom, as well as the decision of the court. This presumes that what courts say is not the law, in other words, inconsistent with Holmes. On the other hand, Senator Douglas and the slaveholders, they insisted that whenever the court spoke, that was the law. Instead, what he is saying is that the precedent isn't necessarily binding if it is not generally accepted, and that he urged the Congress to ignore Dred Scott as a precedent. So let me just read the pertinent part, and it's not complete in his inaugural address. I do not forget the position assumed by some that constitutional questions are to be decided by the Supreme Court, nor do I deny that such decisions must be binding in any case upon which the parties to a suit as to the object of that suit, while they are also entitled to a very high respect and consideration in all parallel cases by all other departments of the government. So that's the part where he's talking about the judgment versus precedent and the weight. The weight is not completely binding on the other departments, he says. Let's continue. At the same time, the candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the instant they are made in ordinary litigation between parties in personal actions, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal. Nor is there in this view any assault upon the court or the judges. It is a duty from which they may not shrink to decide cases properly brought before them, and it is no fault of theirs if others seek to turn their decisions to political purposes. It's clear from everything that Lincoln said about the Dred Scott case, from his grounding in the Declaration of Independence and his insistence on the respect for law, that he is coming from a natural law / natural rights point of view. At this point, I'm not distinguishing between those two. That point of view is inconsistent with the notion that judges make the law, that the Constitution is an evolving document, that they can interpret rights in ways that they choose to, according to what the implications from Holmes's statements. So it's not surprising that we've had so many years under progressives in which, on the one hand, some rights appear to be expanded and other rights at other times appear to be compressed. Because if you take the view that the law is what the judges say, then that's what's going to happen. In this third section of tonight's program, we're looking at primarily Woodrow Wilson. He was president of Princeton, before that a political science professor, and he goes on to be US president. His themes are much of the same in terms of what we just looked at, that is progressivism, positivism, scientism, and most importantly, social Darwinism. So let's begin looking at, listening to what is typical of his speeches. This one is from a speech called "What is Progress?" So let's listen to parts of his speech as they are read.
Now, it came to me that the Constitution of the United States had been made under the dominion of the Newtonian theory. You have only to read the papers of the Federalist to see that fact written on every page. They speak of the checks and balances of the Constitution and use that to express their ideas, the simile of the organization of the universe, and particularly of the solar system. How, by the attraction of gravitation, the various parts are held in their orbits. And then they proceed to represent Congress, the judiciary, and the president as a sort of imitation of the solar system. They were only following the English Whigs, who gave Great Britain its modern constitution. Not that those Englishmen analyzed the matter or had any theory about it. Englishmen care little for theories. It was a Frenchman, Montesquieu, who pointed out to them how faithfully they had copied Newton's description of the mechanism of the heavens. The makers of our federal constitution read Montesquieu with true scientific enthusiasm. They were scientists in their way, the best way of their age. Those fathers of the nation, Jefferson wrote of the laws of nature, and then, by way of afterthought, and of nature's God. And they constructed a government as they would have constructed an orrery to display the laws of nature. Politics, in their thought, was a variety of mechanics. The Constitution was founded on the law of gravitation. The government was to exist and move by virtue of the efficacy of checks and balances.
Wilson is the leader in the assault on the founding. And as you go through this first part of the reading that we've just heard, the number of things he says could form the whole basis of a counter lecture, but let me just give a few thoughts about it. First of all, he ties it to Newtonian theory. Okay, fine. It is common for philosophy, and particular political philosophy, to recognize the philosophical paradigm of the age. But that doesn't mean that because that was a sense of order, as he said, not here, but elsewhere in the 18th century, that it has to necessarily be displaced. He emphasizes it being mechanical. Well, yes, it is in part, but he leaves out the fact that they understood human nature, and that's what they focused on, because his focus is different. It's on the physical sciences. Science has changed. He says that they have an understanding of science as they could understand it in that day. In other words, they're not as bright as we are today. We know so much more. We may know more detail, but do we understand human nature the way the founders did? That's the real issue that he doesn't address. And then he uses the term checks and balances. Now, I've gone through that. We use it a lot, but it's the liberals that use the term checks and balances. The Federalist never does. It talks about the checking in the Congress. And it is true that in Madison's description of separation of powers, it has a checking function, but he doesn't mention separation of powers. Why not? Because the progressives are dead set against separation of powers, which is a core feature, along with federalism, of the Constitution. And he cites the English Whigs. Wait a minute. The Whigs were part of the founding, but they did not dominate the convention. So there's so many things wrong in what he's saying, but let's continue and hear what else he has to say.
The trouble with the theory is that government is not a machine, but a living thing. It falls not under the theory of the universe, but under the theory of organic life. It is accountable to Darwin, not to Newton.
Here you have it. The Constitution, government is not a machine. It is a living thing. Well, yeah, of course, people are living. The body politic is living, and they can live and change through the legislature. But the structure is to restrain the passions of human nature that can get out of control, that can violate rights. But if you're in the democratic mold, as Professor Barnett has been describing in his book, then all of that's got to change. We can't have any restraints. He very much opposes the difficulties posed by the actual Constitution as written.
It is modified by its environment, necessitated by its tasks, shaped to its functions by the sheer pressure of life. No living thing can have its organs offset against each other as checks and live. On the contrary, its life is dependent upon their quick cooperation, their ready response to the commands of instinct or intelligence, their amicable community of purpose.
The whole point of the Federalist explanation by Madison about factions is that it's hard to have a community of purpose when people have so many different views. And the way you would get it would not be for, just community cooperation. The way you would get it is through the process of the Congress. You'd come to a consensus.
Government is not a body of blind forces. It is a body of men with highly differentiated functions, no doubt in our modern day of specialization, with a common task and purpose. Their cooperation is indispensable, their warfare fatal.
Warfare within the United States is fatal, we know that. But the whole point of the Federalist design is to create an alternative way to resolve conflict rather than through war. But this is what Wilson would scrap.
There can be no successful government without the intimate, instinctive coordination of the organs of life and action. This is not theory, but fact, and displays its force of fact, whatever theories may be thrown across its track. Living political constitutions must be Darwinian in structure and in practice. Society is a living organism and must obey the laws of life, not of mechanics. It must develop. All that progressives ask or desire is permission, in an era when development, evolution is the scientific word, to interpret the Constitution according to the Darwinian principle. All they ask is recognition of the fact that a nation is a living thing and not a machine. Some citizens of this country have never got beyond the Declaration of Independence, signed in Philadelphia, July 4th, 1776. Their bosoms swell against George III, but they have no consciousness of the war for freedom that is going on today. The Declaration of Independence did not mention the questions of our day. It is of no consequence to us unless we can translate its general terms into examples of the present day and substitute them in some vital way for the examples it itself gives, so concrete, so intimately involved in the circumstances of the day in which it was conceived and written. It is an eminently practical document, meant for the use of practical men, not a thesis for philosophers, but a whip for tyrants, not a theory of government, but a program of action. Unless we can translate it into the questions of our own day, we are not worthy of it. We are not the sons of the sires who acted in response to its challenge.
From this part, it could not be clearer that, quote, social Darwinism and progressivism are completely at odds with the Declaration. Why? The Declaration talks about truth and human nature. Under certain distorted understandings of science, they've come to a notion that human nature does not really exist in any constant sense.
What form does the contest between tyranny and freedom take today? What is the special form of tyranny we now fight? How does it endanger the rights of the people? And what do we mean to do in order to make our contest against it effectual? What are to be the items of our new Declaration of Independence? By tyranny, as we now fight it, we mean control of the law, of legislation and adjudication, by organizations which do not represent the people, by means which are private and selfish. We mean specifically the conduct of our affairs and the shaping of our legislation in the interest of special bodies of capital and those who organize their use. We mean the alliance for this purpose of political machines with selfish business.
This speech comes 2 years before World War I breaks out in Europe, and he's focused not on that kind of problem, which is a serious problem that will affect the United States and our entry ultimately into the war. But what he's focusing on is restructuring the government. What's the tyranny? These private selfish means. Well, the founding was based on the notion that people act in large part, not completely, for their self-interest. And the idea that there is going to be this totally non-self-interested approach is the premise behind the administrative state. The whole idea was to move lawmaking out of Congress, where there are these selfish interests, and we're going to put them in administrative agencies run by experts, scientists, technical people, who of course are non-political. Wait a minute. Any body in which there are several people, there is going to be some kind of politics. Factions occur everywhere, even in just grade school and high school, the cliques among kids. These are factions, and you get all kinds of factions in government agencies. Anybody who's ever worked there understands that. This is pie in the sky stuff but it hides the real agenda. The real agenda is to change the Constitution. He wants to make it, he says, more democratic. But then why are we putting everything into an administrative agency even further from the voters? There is no consistency here other than positivism, progressivism, and the notion that we says, as he says, we need a new Declaration of Independence. Based on what?
We mean the exploitation of the people by legal and political means. We have seen many of our governments under these influence cease to be representative governments, cease to be governments representatives of the people, and become governments representative of special interests controlled by machines, which in their turn are not controlled by the people. Sometimes when I think of the growth of our economic system, it seems to me as if leaving our law just about where it was before any modern inventions or developments took place.
So there you have it, the political agenda of the left, beginning really with Wilson, and has not changed much since. That is, the details changed, but the agenda is the same in the sense that we can't go back. We've got to evolve. Things are changing. We've got to change. We've got to do things in a different way. This totally ignores the Constitution, wants to rewrite the Declaration of Independence. We will have more about the administrative state in our next and last session. And so now let me turn to the assignment readings or suggested readings for next time. For next week, chapter 8 of Professor Barnett's book, Our Republican Constitution. I'm not going over chapters 6 and 7, that's on constitutional structure and federalism. That's the whole point of the first book club we did in 10 sessions. So if you're interested, as I hope you are, that you'll look at that earlier book club. We're going to take the Scopes trial next week, and that's the so-called monkey trial from Dayton, Tennessee. And we will look also at chapter 2 from the Ethics of Rhetoric, which is an analysis from a dialectical point of view of the trial. And it may surprise you if you get through that chapter as to the viewpoint presented there. Finally, I want you to look, if you have time, at the Supreme Court case from 1927, Buck versus Bell. His citation is 274 U.S. 200. Thank you for joining us this week, and I hope that you will join us next week for the last in the 13th series that we've done on the book club of Reasoned Argument, the Counter to Cancel Culture. Thank you and good night.